Imagine you own like a mid-sized apartment building in Brooklyn, and you're just opening your mail one morning, and this massive multi-million-dollar lawsuit just lands on your desk.
Oh, the absolute worst nightmare.
Right. Someone is claiming they tripped on a cracked sidewalk right outside your property, and they're saying their injuries are devastating, like totally life-altering.
So you're immediately bracing for the financial hit, the skyrocketing insurance premiums, the whole legal nightmare.
Exactly. But then, months later, your defense attorneys finally subpoena the quote-unquote victim's emergency room intake records, and you discover, well, they never tripped on your sidewalk at all.
Wow.
They actually shattered their hand punching a brick wall, or in one case, they literally sliced their finger slipping with a kitchen knife while making dinner.
Which completely flips the script. I mean, the panic of defending this catastrophic personal injury claim just evaporates.
Yeah.
And it's replaced by the realization that you are holding undeniable, medically documented proof of a total fabrication.
And, see, that scenario isn't just hypothetical. Our mission for today's deep dive is to explore this staggering 33-page legal document. It was filed on April 22, 2026, in the Supreme Court of New York, Kings County.
Right, Brooklyn.
Yeah, Brooklyn. And a group of real estate companies, Dira Realty LLC, and 5 affiliated property-owning LLCs are essentially turning the tables.
They're going on the offensive.
They really are. They're no longer the defendants. They are suing a personal injury law firm called Asher and Associates PC, along with 5 of that firm's clients. And the accusation is a massive coordinated fraud and racketeering scheme.
And the broader implications here are just fascinating, because we are looking at a masterclass in how undeniable paper trails, specifically, hastily scribbled notes taken by ER triage nurses, can spectacularly dismantle fabricated legal narratives years after the fact.
Okay, let's unpack this. Because before we dive into the anatomical impossibilities and the wild individual claims, we need to understand the blueprint of this alleged scheme.
Right, how did it actually work?
So, according to the complaint, the Asher law firm allegedly recruited individuals who had suffered completely mundane everyday injuries. We're talking kitchen accidents, fistfights, pre-existing joint issues, that sort of thing.
Things that happen to people all the time.
Exactly. And instead of just letting these people use their regular health insurance, the firm allegedly filed lawsuits claiming every single injury was the result of a trip and fall on a defective sidewalk. Specifically, sidewalks adjacent to Dira Realty's properties.
And a crucial common denominator across all these claims is the complete absence of contemporary evidence.
Right.
Every single one of these alleged sidewalk accidents was entirely unwitnessed. Nobody saw them fall.
Convenient.
Very. And not a single plaintiff reported the hazard to the building superintendents at the time. They supposedly sustained these life-altering injuries, vanished from the scene, went to a hospital, and then lawsuits just materialized much later.
Yeah, the financial target of this operation is what really caught my eye. They were specifically aiming to drain the real estate company's self-insured retention fund.
Sarah, right?
Yeah, which was managed by a third-party administrator called ESIS. And for anyone outside the commercial insurance world, a self-insured retention fund is functionally a massive corporate deductible.
So the company pays first.
Exactly. Dira Realty had to pay out of their own pocket for defense costs and settlements up to $500,000 before their actual umbrella insurance policy would even kick in.
And that $500,000 threshold is the key to the entire strategy here.
How so?
Well, if you sue a massive multinational insurance conglomerate, they have dedicated, aggressive fraud investigation units. They will dig deep. But a mid-sized real estate holding company relying on a third-party administrator that has a very different risk profile.
Oh, interesting.
Yeah, because third-party administrators like ESIS, they're generally evaluated on how efficiently they clear claims off the books.
Okay, but I have to push back on that logic for a second. If the real estate company is paying the first $500,000 out of their own pocket, wouldn't they fight tooth and nail to defend every single penny? I mean, why would the fraudsters assume they'd just roll over and write a check?
Well, because the fraudsters are banking on the cold, hard mathematics of civil litigation.
The math.
Exactly. Taking a case all the way to a jury trial in New York, hiring biomechanical experts, conducting multiple depositions, paying defense attorneys by the hour, it can easily cost $100,000 or more. And there's no guarantee of winning.
That's a huge gamble.
Right. So the scheme relies on the defense calculating that, offering a $30,000 or $50,000 settlement to simply make the headache go away is just the cheaper, safer business decision. The system is designed to act like an assembly line, pushing paperwork toward a settlement to avoid those exorbitant costs of a trial.
It's essentially exploiting the math of a nuisance fee. It reminds me of someone taking a broken TV from their living room into an electronics store and demanding a refund for a display model.
That's a great analogy.
Like, the story relies entirely on the manager just glancing at the receipt and handing over the cash without actually checking the serial numbers. Because the moment you look at the physical evidence, the lie completely falls apart.
Which brings us to the medical realities of these claims. The fatal flaw in this operation wasn't just poor coordination.
Right.
It was the undeniable laws of physics.
The boxer's fracture cases, these are the perfect example of this. We have multiple plaintiffs in this lawsuit who claimed they tripped and fell, landing on their hands.
Right.
So Keystan Caesar, he claimed his foot caught on a crack outside 921 Montgomery Street in March 2023. He says he was pulling a laundry cart, let go, and fell face forward, palms first, onto the concrete.
But the mechanism of injury is everything in orthopedics. Dr. Zhu and Dr. Cho, the medical experts who reviewed the x-rays, testified that Caesar suffered a displaced fracture of the second metacarpal neck.
Which is where, exactly?
For anyone looking at their own hand right now, that is the bone leading up to your index finger knuckle.
Okay, and a palm first fall onto concrete that cannot snap that specific bone in that specific way, right?
What's fascinating here is how kinetic energy travels through the human skeletal system. If you fall forward with an open palm, your wrist is extended.
Sure, natural reflex.
Right. And the force of the impact hits the heel of your hand and travels directly into the radius and ulna, your forearm bones. That usually results in a callus fracture or a break in wrist.
So not the knuckle.
No. To break the metacarpal neck, the force has to be applied via an axial load, meaning the force strikes the knuckles directly while the hand is in a closed fist.
Wow.
It is structurally impossible to sustain a boxer's fracture from an open palm fall.
It's like claiming you got a sunburn indoors while wearing a snowsuit. The physical evidence completely rejects the story. And the ER records totally back up the physics here.
Oh, they always do.
Yeah, when Keystan Caesar arrived at Kings County Hospital, the intake notes literally state he complained of hand swelling after, quote, punching a brick wall, unquote.
A brick wall.
Yes. And he actually later admitted he punched a stranger in the face.
Unbelievable.
So the physical damage matched the ER confession, not the lawsuit.
And that pattern repeated itself with startling consistency. Another plaintiff, Manquarvius Johnson, claimed a New Year's Eve sidewalk trip in 2022.
Okay.
Yet he presented at the emergency room intoxicated the very next morning on New Year's Day, admitting he injured his hand in an altercation.
Another fight.
Yes, and the triage notes even document a fight bite.
Wait, what is a fight bite?
It's a specific type of abrasion over the knuckle caused by striking another person's tooth.
Oh, gross.
Yeah, and the diagnosis was, again, a boxer's fracture.
And then there's Earl Simmons. He claimed a sidewalk trip in September 2024, but the SUNY downstate records, quote, him complaining of wrist pain, quote, post a physical altercation where he punched someone in the face with a closed fist.
The mechanism is identical, and this highlights a profound psychological dynamic in emergency medicine. When people are in severe acute pain, their immediate priority is getting effective treatment, not preserving some hypothetical future lawsuit.
They just want the pain to stop.
Exactly. Doctors require the exact mechanism of injury to determine if there is soft tissue damage, tendon rupture, or infection risk, especially with something like a fight bite.
Right, because of bacteria.
Yes. The patient tells the truth to the doctor out of self-preservation, which creates an unalterable paper trail at the very genesis of the timeline.
Well, here's where it gets really interesting. Because while those first three plaintiffs were undone by, basic skeletal mechanics, the remaining cases in this complaint collapse under the sheer audacity of their medical histories.
Some of my cases.
Yeah, the Donald Veazey claim is just a masterpiece of contradiction. He swore under oath that a June 2023 trip on a sidewalk flag caused catastrophic right knee damage requiring surgery. And he explicitly testified that he was in perfect health prior to the accident.
But the defense's investigation into his medical background revealed a reality that was entirely the opposite. The medical records depict a multi-year saga of chronic knee pain, instability, and just varied traumas.
It's basically a medical encyclopedia of bad luck.
It really is. He had prior hospital visits for fainting spells, full body weakness, and getting kicked in the leg. He was even treated after falling down a flight of subway stairs.
And it gets worse. Just 6 weeks prior to this supposedly life-altering sidewalk trip, an MRI on that exact same right knee showed a severe chronic condition called patella alta.
Which means his kneecap was abnormally high.
Right. And he also had a radial tear of the meniscus.
Right.
Furthermore, the surgery he eventually claimed was necessitated by the sidewalk fall. It was actually a patellar tendon shortened procedure to address a rupture that originally occurred in 2010.
And the timeline proximity is the most damaging element here.
Literally days before the alleged sidewalk incident, VZ went to the emergency room because he rolled his ankle stepping off a city bus and couldn't bear weight on the leg. The pre-existing structural damage was just overwhelming.
Completely.
And then you have to add the final plaintiff, Clive Brown. He sued for severe right hand and finger tendon lacerations from a sidewalk trip in February 2022. But the Kings County Hospital records explicitly state his injuries resulted from a, quote, knife slip in kitchen.
A kitchen knife.
Yeah, so I have to challenge the legal mechanics of this. I mean, Asher and Associates is a functioning law firm.
They are.
They have to know that defense attorneys will subpoena medical records. So why would any lawyer file a lawsuit if the foundational hospital note literally says kitchen knife? Like, how does a firm let that slip through?
Well, this raises a really important question about the volume-based business model of some personal injury practices. Firms operating on this scale often function as mills.
Mills, okay?
Yeah, they take on hundreds of cases and do very little initial due diligence. They just rely on the client's initial narrative and file the paperwork, assuming that in Shuhaya, the federal health privacy law will act as a temporary shield.
Because APA strictly protects your medical history.
Right. But the moment a plaintiff files a personal injury lawsuit claiming specific damages, they legally place their physical condition into controversy.
So they basically waive that privacy for the injured body part.
Precisely. The defense utilizes the discovery process to legally compel the release of those records. The firm filing the lawsuit might genuinely not possess the ER notes when they file the initial summons.
So they're flying blind.
Exactly. They're simply rolling the dice, hoping the defense settles before the costly discovery phase unearths the kitchen knife note.
Wow. So what does this all mean for the Dira Realty companies? Because once their defense attorney, Smith Mazur PC, pulled these records and realized they were dealing with 5 identical patterns of fabricated claims from the same firm, they didn't just quietly file for dismissal.
No, they weaponized the evidence.
They really did. The complaint details that Smith Mazur repeatedly warned the Asher firm. They presented the contradictory ER notes during depositions. They sent emails, and they formally requested the cases be dropped.
Giving them every chance to walk away.
Right. But when the Asher firm knowingly continued to prosecute the claims, despite the overwhelming evidence of fraud, the defense just transitioned into an aggressive counteroffensive.
Which is when things get really serious.
Oh, yeah. They filed suit for common law fraud, attorney misconduct under New York Judiciary Law 487, and deceptive practices under General Business Law 349. But the nuclear option, the part of this 33-page complaint that absolutely blew my mind, is that they are deploying RICO against a local personal injury firm.
The Racketeer Influenced and Corrupt Organizations Act.
Yes. And the history of RICO makes this so compelling. I mean, this statute was explicitly designed in the 1970s to dismantle the mafia.
Right, the mob.
Exactly. It was created because prosecutors kept catching low-level foot soldiers committing crimes, but they couldn't touch the bosses giving the orders. RICO allowed the government to prosecute the entire organized structure. So seeing a law designed for the Gambino crime family deployed over Brooklyn slip-and-fall claims is just jarring.
It is. But if we connect this to the bigger picture, civil RICO is a uniquely devastating tool in corporate litigation. You do not need a criminal conviction or a literal mafia don to bring a civil RICO claim.
Really?
No. The statute simply requires the plaintiff to prove the existence of an enterprise, in this case, the law firm and its clients engaging in a pattern of racketeering activity over a continuous period.
And the specific racketeering activities alleged here are wire fraud and mail fraud.
That is the mechanical genius of the countersuit. Every single time the Asher firm electronically filed a fabricated court document through the New York court system's digital portal that constituted an alleged act of wire fraud.
Wow.
And every time they utilized the Postal Service to mail a fraudulent letter of representation or a phony medical demand, they committed alleged mail fraud.
So it adds up fast.
Very fast. By stringing together dozens of these individual administrative actions across 5 separate clients over several years, the defense establishes the requisite pattern.
And the financial mechanism of a RICO claim is what makes it a death sentence for a business. Dira Realty isn't just seeking to recoup the money they spent defending these bogus lawsuits. Civil RICO statutes allow for the awarding of treble damages.
Triple damage.
Right. That means the court takes the actual financial damages, the money paid to third-party administrators, the hourly fees for the defense attorneys, the quantified increase in the real estate company's insurance premiums, and legally multiplies that final number by 3.
And the threat of treble damages entirely changes the calculus of civil litigation.
It has to.
Normal malpractice or fraud claims might just represent the cost of doing business for a corrupt firm. But RICO is designed to financially vaporize the enterprise. Furthermore, the statute mandates that the losing party covers all of the prevailing party's ongoing attorney's fees.
Which ensures that the victim doesn't go bankrupt trying to prove the fraud. It is a spectacularly aggressive legal maneuver. To sum it all up, a group of individuals and their legal representation allegedly attempted to treat a mid-sized real estate portfolio like an infinite ATM.
Yep.
And they relied on the statistical probability that the insurance administrators would just pay the nuisance fees to make the claims disappear. Instead, they collided with the undeniable biological reality documented by emergency room triage nurses.
And now they're paying the price.
Yeah, they are now facing a racketeering lawsuit that threatens to multiply their liability and dismantle their operation entirely.
Because the entire case hinges on the durability of the medical record. A lie can be meticulously crafted and legally formatted, but the physical truth of a fractured bone or a kitchen knife laceration leaves an indelible, unalterable footprint.
Which brings up a fascinating paradigm shift to consider for you, the listener, as we wrap up this deep dive. This entire multi-million-dollar racketeering countersuit was built on handwritten triage notes and hospital billing codes from a few years ago.
Just basic notes.
Right. So think about the sheer volume of biometric data you generate today. We wear smartwatches that track our heart rate. We have accelerometers in our phones that measure our gait, and sleep trackers that monitor our precise movements.
It's constant tracking.
It is. If a hastily scribbled note about a brick wall can unravel an entire legal scheme today, imagine what happens in the near future.
That's a wild thought.
We are rapidly approaching an era where AI predictive models will cross-reference a personal injury claim against the plaintiff's own wearable health data. The next time someone claims they suffered a catastrophic fall on a sidewalk, their own heartbeat, GPS coordinates, and gyroscope data might already be sitting on a server, quietly preparing to testify against them.